opponents, 209, say that affirmative action treats people differently based on their race.
Yes, they treat people differently because they need to be treated differently.
And why do they need to be treated differently?
Because they have been discriminated for a long time, and without different treatment, they could not be on the same equal basis.
So, suppose a town enacts an affirmative action program. Say the city of Davis adopts an affirmative action program, and over time it says, we don't think we need this program anymore. Black people and white people now are similarly situated. We've overcome the effects of past discrimination. We're going to repeal the affirmative action program. Do you think that the city of Davis would have the right to do that?
No, I believe it does, but in this case, if you look at the Proposition 209, we do not believe that California State has given enough justification to eliminate affirmative action. They did say in the California ballot pamphlet that majorities are being discriminated because of affirmative action. But did they give any reason or evidence? No. So we believe there's no justification to eliminate affirmative action at this moment in the state of California.
Yeah. Is affirmative action required by the Equal Protection Clause?
Equal Protection Clause does not specify that the minorities and women should be treated, should have preference treatment.
So it would be constitutional for the state of California not to create an affirmative action program in the first place? Because the Equal Protection Clause doesn't require it.
But it does not deny preference.
That's right. It doesn't deny it, at least in some circumstances. But since it doesn't require it, what's wrong with the state of California deciding not to make it available?
Because we believe we still need affirmative action.
And suppose the people of the state of California disagree with your council and with the NAACP and exercise their political discretion not to have affirmative action.
But that's why we're asking for compelling state interest. Because without compelling state interest, we do not see any reason why we need to prohibit affirmative action at this moment.
Let's focus on the provision in 209 that deals with sex, with gender. Why do you think that the women in California aren't capable of performing and competing for jobs just as effectively as men?
I think they are. They have the ability, and they probably do have a educational background as well. But I think the problem here is, do they have the opportunity to get the right kind of job that they have the ability to do so?
Well, I might take judicial notice of the fact that California has 2 United States senators. They're both women. Meg Whitman, who is a woman, is running for governor
Yes,
in California.
The number of men and women, I think it's still the number of women having high quality jobs still small.
So, because discrimination continues against racial minorities and women in California, and their opportunities are limited, the state cannot eliminate affirmative action without demonstrating a compelling state interest. Thank you, guys.
Good afternoon.
Good afternoon. I'm very interested in hearing your argument, because once strict scrutiny is applied, your side has a much easier job. But you need to convince me that the compelling state interest standard is appropriate.
I also do so.
Okay.
I would like to present our second argument. Your Honor, and that is that Proposition 209, discriminating the woman and the minority in the on its face but on its facts. 14th Amendment provides equal protection for all people. So looking back at will discriminate minorities and women again. They will have lower chance to be employed in public. The enrollment of Afro-Americans, Latino and American Indian students in public colleges will decrease. As the Supreme Court said, as the Supreme Court said in Washington versus Seattle case, environment is largely shaped by members of differential racial and cultural groups. Minority children can achieve their full measure of success only if they learn to function in and fully accepted by the larger community.
But now, do you read Seattle School District to say that affirmative action programs are required by the Equal Protection Clause?
It is not directly required, but it is not prohibited as well.
Okay, but if it isn't required, does that mean that a state is permitted not to create affirmative action programs? Did the state of California elect not to create an affirmative action program?
Well, I think that's not the point in our case, because they prohibit affirmative action. So
Well, isn't what's happened here is that we've had some programs and now the state is taking them away, repealing them.
yeah, but I think we strongly believe that it's not the time to eliminate affirmative action, because we haven't reached the same level for everybody in this country.
And as a public policy matter, I might agree with you, but as a constitutional matter, is this issue entrusted to the political branches of government to decide whether affirmative action is necessary and how large an affirmative action program should be created? Or is this something that is subject to constitutional adjudication? If it's not required, that sounds like it's for the political branches of government or the people to decide.
Of course, it is a political argument as well, but I think the Constitution, the 14th Amendment, wants us to have equal protection for everybody. And until now, it is not. We haven't seen the ground on this. So we strongly believe that we should have more affirmative action. As you mentioned before, of course, there are some governors that are female, or maybe we have Obama as president, but it is not enough for minorities and women right now. Because if you see how many people are in, how many members are in House of Parliament, Congress, are whites, and how many are Afro-Americans or Asians, then you will see that we're not on the equal protection, that we have not reached the equal protection in this country.
But again, I mean, I think that's a powerful argument. The question is whether it's a constitutionally compelling one. If the University of California, for example, created an affirmative action program 10 years ago because there weren't enough women professors or African American professors, and then this year it decided to change the policy and it eliminated the affirmative action program, and African American and women petitioners came to this court and said it's too early to eliminate the affirmative action program. The program still is necessary to create equality. Could you argue to this court that it is unconstitutional for the University of California to decide that the affirmative action